Negotiable Instruments Act, Section 98, when notice of dishonour is unnecessary. Section 98 of the Negotiable Instruments Act, 1881 specifies the situations in which notice of dishonour is not required to be given, although such notice is generally necessary to hold certain parties liable on a negotiable instrument. The section recognizes that in some circumstances notice of dishonour would be unnecessary, impossible, or meaningless, and therefore dispenses with the requirement of giving such notice. 1. Purpose of the provision. The object of Section 98 is to avoid unnecessary formalities where notice of dishonour would serve no practical purpose, particularly in situations where the party already knows the relevant facts or no prejudice can result from absence of notice. The section also recognizes cases where giving notice is impossible or unnecessary, and therefore balances procedural requirements with commercial practicality and fairness. 2. Notice dispensed with by party entitled. Notice of dishonour is unnecessary where the party entitled to receive notice has waived or dispensed with such notice either expressly or by conduct implying waiver. Once the right to notice has been waived, the holder is no longer required to comply with the formal requirement of giving notice of dishonour. 3. Drawer has countermanded payment. Notice of dishonour is not necessary to charge the drawer where he himself has countermanded payment by instructing the bank not to honour the cheque or instrument. Since the drawer himself caused the dishonour and already knows that payment will not be made, formal notice becomes unnecessary. 4. No possibility of damage. Notice of dishonour is unnecessary where the party charged could not suffer any damage or prejudice because of the absence of such notice. The law does not insist on notice where the party already knows about the dishonour or could not have acted differently even if notice had been given. 5. Party cannot be found or notice impossible. Notice of dishonour is unnecessary where the party entitled to notice cannot be found after due search or where the person required to give notice is unable to do so without fault on his part. The provision protects honest parties where notice becomes impossible despite reasonable efforts, provided that such inability does not arise from their own negligence or fault. 6. Acceptor also a drawer. Notice of dishonour is unnecessary to charge the drawer where the acceptor is himself also a drawer of the instrument. In such a case the party already knows the facts relating to dishonour, and therefore formal communication serves no useful purpose. 7. Non-negotiable promissory note. Notice of dishonour is unnecessary in the case of a promissory note that is not negotiable and therefore does not circulate through negotiation like ordinary negotiable instruments. In such cases the need for formal notice is reduced because the parties are already directly connected with the underlying transaction. 8. Promise to pay despite knowledge of dishonour. The section further provides that notice of dishonour is unnecessary where the party entitled to notice, after knowing the facts of dishonour, unconditionally promises to pay the amount due on the instrument. Such a promise amounts to acknowledgement of liability and waiver of notice, and the law therefore treats formal notice as no longer necessary. For more details contact us.